the National Director of Sales and Government Services at Advanced Integrated Solutions, and I'll be your host for today's webinar. I serve as the Vice Chair of Education and Training for the SAME Small Business Council, who is sponsoring this webinar today. The mission of the Small Business Council is to promote the role and relevance of the small business in SAME through outreach, training, opportunity, and recognition. We inform SAME of technical programs of interest to small business members, provide opportunities to meet with key military decision makers, represent small business interests on select SAME national committees, and keep members informed on small business regulations and legislation. If you're interested in getting more information about the Small Business Council activities, please be sure to join our email distribution list and follow us on LinkedIn. In an effort to engage the small business community and other members of SAME, we have organized the webinar today to provide clarity and additional insights on one of the Small Business Administration's recent changes that impacts the federal contracting community in a significant way. Following the webinar, the presentation will be emailed to all attendees within several business days, and please watch for follow-up email containing the presentation, PDH certificate, and a link to the recording of this webinar. This webinar would not be made possible without our presenter, Mr. Steven Koprince, so I would like to sincerely thank him for his participation and support of SAME and the small business community. I would also like to thank each of you for joining us today. Looking forward to the presentation and our Q&A session that immediately follows, and I encourage each of you to send in your questions as they arise, although we may answer the questions following the conclusion of the presentation just because of time. After this webinar, you will also be automatically routed to a survey page. Please participate in this short poll so we can address any concerns for future webinars. I'd now like to introduce our speaker who will lead the discussion today. Steven Koprince is the founder and managing partner of Koprince Law, LLC, a law firm dedicated exclusively to providing legal solutions to federal government contractors. Steven is the author of the Small Business Guide to Government Contracts, which is a compliance guide designed to help small businesses navigate the federal marketplace. He regularly blogs on small business government contracting issues at smallgovcon.com. Steven's work has been published by leading industry and legal publications, including the Contract Management Magazine, the Procurement Lawyer, the Federal Lawyer, Law 360, and many others. Steven is a graduate of Duke University and the Marshall Witt School of Law at the College of William and Mary in Virginia. Without further ado, I pass the call over to Steven.
Well, thank you, Alex. Thank you, Nicole, as well, and a big thanks to the SAME Small Business Council for hosting this event, and of course, thank you to everyone who's taken a little time out of your day to attend. I see we've got a pretty good crowd here today, and understandably so, because this is a really major initiative in government contracting, this new Small Business Mentor-Protégé Program that the SBA has recently adopted. I'm having, in my legal practice, lots of clients, both large businesses and small businesses, who are very interested in this program, want to be able to take advantage of it, want to know what the rules are, how it works, how it can benefit them, and so that's what this program is all about. So before we go ahead and get started, just a couple housekeeping items. As Alex mentioned, we do welcome questions as part of this presentation. I certainly hope that you'll ask a question if you have it. We probably will hold the question period till the end. I intend to leave some time to answer questions at the end. So just because you've asked a question, if I haven't answered it right away, don't worry. We'll likely be able to get to it. If there are too many questions to fit in, then we'll try to answer questions for folks offline. Please do keep in mind, if you do ask a question, that this is an educational seminar. It's meant to educate you on the Small Business Mentor-Protégé Program, the rules, requirements of that program, how to go about taking advantage of it. It is not a forum to provide individual legal advice. So if you have a specific legal question about the specific situation you face, that's a discussion that you can have offline with your counselor or have offline with me, but if it's too specific to your scenario, then it's not a question that we'll answer as part of this forum. That said, please take a look. If you are interested in reaching out afterwards, I do welcome you to do that by email, telephone, and contact information down there. You can find out more about our firm at koprince.com. And of course, visit smallgovcon.com. That's our blog. We've been publishing that, my colleagues and I, for about 5 years now. We're almost up to 1,000 posts on there, so we're writing a lot about government contracting law. It changes that much. There's that much going on, including, of course, we wrote some posts on this Mentor-Protégé program. But if you haven't visited it, please feel free to go ahead and do that. You'll see that our posts we try to write directed at smart business owners, but not folks who spent too much of their life in law school, not a lot of Latin phrases and all that gobbledygook that it seems that too many of my professional legal colleagues put in their posts. So smallgovcon.com, and you can also sign up there for our free newsletter. So without further ado, let's go ahead and get started. Here's what we're going to be talking about today. Before we get into the meat of the all-small Mentor-Protégé program, which of course is the crux of this presentation, I think it's important to understand a little bit of background about federal Mentor-Protégé programs generally, where they came from, what they're intended to do, the special affiliation and joint venturing exceptions when those apply, because when folks are talking Mentor-Protégé with me, those pieces inevitably come up, and then how those relate, how those fit in with this new program. So that broader context, I think, folks tend to find useful in my discussions with clients and others about Mentor-Protégé programs, what they are, where they come from, and why now we've arrived at this all-small, government-wide, universal Mentor-Protégé program that's being run by SBA since October. And then we will start right away with an overview of Mentor-Protégé programs generally. So what is a Mentor-Protégé program? I think that's, some of you on this call, obviously, you know exactly what that is. But there is quite a bit of confusion out there about what a Mentor-Protégé program is, what a Mentor-Protégé relationship is. In fact, when I get, and don't be embarrassed if this is you, because I get this misconception from very smart contractors all the time, but there is a significant misconception out there that a mentor-protégé, just a mentor-protégé generally, is a form of teaming relationship. So folks will come to me and say, I want a mentor-protégé for that contract over there. We want a mentor-protégé for that solicitation. It's almost viewed as an alternative to a prime subcontract team or a joint venture, some sort of teaming relationship in its own right. And that's not what a mentor-protégé is, not under the federal government rules. A Mentor-Protégé program, and again, don't be embarrassed if this is you, because this is a very common misconception, because the Mentor-Protégé program is intertwined with teaming and joint venturing in a certain way, and we'll get to what that is. And so it's logical for folks to assume that the Mentor-Protégé itself is some sort of team. It's not. What it is at its heart is an agency-approved arrangement under which a small or socioeconomically disadvantaged business, and you don't have to be socioeconomically disadvantaged for all small, we'll talk about that, receives financial, technical, educational, or other types of assistance from an established government contractor. That's really what it is, and that's not a definition you're going to find in the regulation. That's my words there. But when I talk to my clients and others about Mentor-Protégé programs, generally I say the first thing to know about a Mentor-Protégé program is it's an assistance program. That's what it is at its heart. It's an assistance program under which a more established, usually larger business provides some forms of assistance, and those are up to the parties to decide typically what they are, to a smaller, less established business. That's generally what a Mentor-Protégé program is. It's an assistance agreement. And you can have a Mentor-Protégé relationship between a more established business and a less established business, more experienced, less experienced, however you want to look at it, larger, smaller, without ever joint venturing or teaming together. You may never pursue a contract together because the Mentor-Protégé program doesn't require you to do that. Most of these companies do. That's one of the relationships, or one of the reasons that folks want to get into a Mentor-Protégé relationship, is to avail themselves of those advantages. But Mentor-Protégé is an assistance program that offers certain teaming and joint venturing benefits. It is not in itself a teaming or joint venturing program. So that's what it is. And it's important to note that it's an agency-approved assistance program. Agency-approved. In this case, we're talking about SBA-approved. Other agencies run Mentor-Protégé programs, and we'll touch on those. But an agency-approved arrangement, as I often say to folks, if you have an informal Mentor-Protégé arrangement, because I get a lot of people call me up and say, I've got a mentor, And then we talk, I said, well, what's your sponsoring agency? Which agency approved it? None. It's an informal relationship. And there's nothing improper about that, except that in the government's eyes, an informal mentor-protege relationship is no mentor-protege relationship at all. And you don't have the special benefits of mentor-protege relationships that are approved by the federal government. In fact, depending on the nature of the assistance flowing under an informal relationship, you may be putting yourselves at risk of an affiliation finding from the SBA. So you have to have a written mentor-protege agreement. Every mentor-protege program out there, including all small, which is, of course, our focus today, requires a written mentor-protege agreement that outlines the assistance, typically providing milestones and specific details about how that assistance is going to be provided. You have to have the approval of a sponsoring agency. The special affiliation, joint venturing benefits that we'll talk about here don't kick in unless and until the SBA approves the mentor-protege agreement. And it's true for benefits under any other agency's mentor-protege program, notably DOD's, that the agency has to approve the arrangement before the special benefits kick in. And that's why the last bullet says approved mentors and proteges are entitled to special benefits. And there's no benefit, the benefits don't kick in when the application is submitted. That's a common misconception. As long as we've submitted the application, we can start doing this stuff together, not until it's actually approved by, in this case, with all small, the SBA. So who runs mentor-protege programs? So we're talking today primarily about the SBA's all small, and that's where most folks are going to go for a variety of reasons that we'll get to. But a lot of agencies currently at least have on the book, some of them aren't currently running them, have mentor-protege programs. You see a list of agencies here that have had mentor-protege programs that are currently on their books. Some of them are active programs accepting new applicants. Some are not, for reasons we'll get to shortly. But you see these are the programs before all small. You see SBA 8A down there in the lower right-hand corner. The SBA did run a mentor-protege program, and I'll discuss the history, but it was only for 8A companies. And so these other agencies, in a lot of cases, had much broader capability to be a protege. Most of these agencies, not all, VA wanted you to be a SDVOSB or VOSB, but most of the agencies would allow a hub zone company to be a protege, would allow a small disadvantaged business that's non-8A to be a protege, would allow a woman-owned small business to be a protege. And those companies couldn't participate in an SBA mentor-protege program until now, so other agencies kind of filled the void, your Treasury, NASA, et cetera, DOD kind of being the granddaddy of these under this what's called a pilot mentor-protege program. It's been a pilot program for 30 years or so. I think they finally have removed that, designation from it. All right, moving on. So how do you be a protege? Well, we talked a little bit about this. To be a protege, you have to be in the SBA world. Before all small, you had to be an 8A company. If you wanted to be a mentor-protege, part of the VA's mentor-protege program, you had to be an SDVOSB or veteran-owned small business, and then, as I mentioned, pretty much any other what's considered socioeconomic category of small business, woman-owned, hub zone, small disadvantaged businesses that weren't certified would qualify. Who can be a mentor? Well, it's a common misconception that you have to be a large business to be a mentor, and as we'll talk about, that is true for the DOD. You know, the DOD's mentor-protege program has long been had a different mindset. It's targeted toward large DOD prime contractors, and it's designed to get them essentially to have stronger subcontracting relationships with small businesses. So unlike the SBA's programs, which are really directed at small prime contractors, at least first, that's the first philosophy, DOD's program has long been directed primarily at increasing subcontracting opportunities for small businesses with large DOD primes who are operating under active DOD subcontracting plans. And so DOD does say you have to be a DOD prime contractor, essentially, to have to be a mentor. But in other agencies, that's not true, including SBA. The SBA requirement, and it's mirrored by most agencies that run mentor-protege programs, has long been that any business, large or small, can be a mentor. You would, or have to have the resources, capabilities, et cetera, necessary to effectively provide the assistance that's being offered under the Mentor-Protégé Agreement. So you can't just be, in most cases, a startup, but as long as you have the ability to meet the commitments and have the capabilities, have the profile of someone who could assist, then you can be a mentor, even if you're technically a small business or a small business in certain NAICS codes. You know, and I have clients of mine who are facing that nice yet difficult challenge of growing out of their size standards. You know, that happens to a lot of successful government contractors who have been getting work through small business set-asides, through socioeconomic set-asides, and they've been successful. And in fact, they've been so successful that they start growing out of their size standards. And one effective way that some of these clients, even as they're approaching, they can see, they say, hey, you know, these size standards, if we're in a revenue-based NAICS code, for example, it's a 3-year running average, we're projecting that by the end of 2017, when we have to include those numbers, we can see what our contract revenue is likely to be this year, that we're going to be large. What can we do? You know, we're now, you know, there's 2 categories of business in government contracting. There's small, and there's what the SBA calls other than small. There's no medium. There's been this long push for a mid-tier advocacy, but, you know, as I tell my clients, you're either small or you're Boeing, you know, as far as the government's concerned. So you're in a very different playing field when you outgrow your size standard. What some of these companies do, even as they're approaching the end of their life as a small business and going to take that next step, they want to keep their foot in the set-aside arena. It's a good time, even when they're still small, to become a mentor to a small business that's going to have a lot of room to run in the small business field, and start working with that business, that protege business, to keep a foot in the small business sandbox. So that's a strategy that some companies are using even when they're still small. They're approaching the end of being small, but they're becoming mentors with an eye toward the future. Why would a protege do this? I think it's pretty obvious from the protege perspective. And we talk about how this is an assistance program. And so what can a protege get out of it? Well, all sorts of stuff, because the crux of a mentor-protege agreement is that the mentor is providing stuff to the protege. And if you're a protege and your mentor is taking their obligations seriously and they're implementing them in good faith, and they've put in their agreement real things of value to you as a protege, which hopefully they have, that's what you've agreed on, then it can be a very beneficial arrangement. For financial assistance, you know, it could be loan guarantees, bond guarantees, direct injections of capital in some cases, less likely, no interest loans directly from the mentor. A proposal assistance. We see a lot of mentors who are helping their proteges learn to write good, strong, competitive proposals, improve their proposal writing capabilities. FAR and regulatory training, industry regulations that might apply, helping the proteges develop their knowledge. Marketing assistance, that's a big one. You know, I go to a lot of industry, government contracting industry events across the country. You know, I've in several cases run into the people I didn't know were there, you know, a protege or a mentor, and they're there. They got booths next to each other. The mentor is helping, you know, introducing the protege to their contacts, people in government, other potential vendors, suppliers, allies that are out there. So that sort of, you know, that sort of just relationship assistance can be good, as well as, of course, developing a strong marketing plan and strategy. Some proteges have done really well working with their mentors on that. Subcontracts, you know, both the DoD and other programs do encourage the mentor to subcontract to the protege. DoD really kind of requires it almost, but the ability to get subcontracts from your mentor to grow that past performance, to grow some revenues while doing real work, very valuable. Formal, informal training in other fields. Bonding assistance I mentioned up there, kind of as financial, but for construction companies, a real advantage to having a mentor is that mentor almost always is agreeing to provide some sort of bonding assistance to the protege, which could be a real sticky point for small construction companies dealing with those bonding requirements. And then joint venturing, you know, in the SBA 8A and now in the new all-small program, and historically it's been just in the 8A, but in the new all-small program, we'll talk about the joint venturing benefit. And it is important to note, and I'll go over this again, but I do want to reiterate it because it's important, is that The special joint venturing benefit we're talking about, the mentor-protégé joint venture benefit, is available only in the SBA's programs. 8A, all small. In the other agency mentor-protégé programs are out there, including DOD, but your NASA, DOT, et cetera, the joint venturing benefit doesn't exist. It doesn't mean you couldn't necessarily joint venture with your mentor if they're also a small business, and we'll talk a little bit about that. But the special joint venturing benefit that we'll go through only available under the 8A and all small mentor-protégé program. And so sometimes folks come to me and they say, well, which mentor-protégé program is right for me? And if the answer is we want a joint venture and the mentor's large business, then the answer is the SBA program, either 8A or all small is appropriate. Now, why do mentors do this? We get why protégés do this. Why would a mentor want to do this other than the warm fuzzies they get by mentoring a small business? Well, in the DOD world, they're going to get some credit toward their subcontracting plans. Dollar for dollar, sometimes 2 to 3 times the dollars spent mentoring the protégé is counted toward subcontracting plans. You may get an exception from affiliation, and that's a real important benefit that's available in the SBA's 8A program, the new all small program, and the DOD program, but not available in the other programs. I am going to go through that on a little bit greater length as well, because that's an important thing. By affiliation, I'm sure most on this call know that, but affiliation is a size concept. It's an SBA size concept. It's a question of whether, when the SBA is determining whether a particular company is or is not a small business, the SBA includes either the revenues or employee count, as the case may be, based on the size standard of another business. And so if I own 100% of 2 companies, they're affiliated by virtue of common ownership. It's an easy example of affiliation. But affiliation can arise for lots of reasons. And one of the reasons affiliation can arise, for example, is what's called economic dependence, contractual relationships. And so if I'm a small business and over the course of several years I derive, let's say 80, 90% of my revenues, anything more than 70% of my revenues from a single large business, then ordinarily I'm going to be affiliated with that large business by virtue of economic dependence, a little understood affiliation rule, but one that really can get people in trouble. However, if that large business is my mentor, then those dollars are off the table. SBA can't use them to find affiliation if they're my mentor in the SBA 8A program, the all small program, or the DOD program. So, and other things that could be part of the SBA's basket when they're determining whether an affiliation exists, things like, is the company getting free office space from the mentor? Are they sharing resources, equipment, facilities, et cetera? These things go into the SBA's bucket sometimes when deciding whether there's an affiliation. If it's covered by the mentor-protégé agreement, the agreement's active, and it's an SBA or DOD mentor-protégé agreement, SBA will not use it to find affiliation or control. So very important exceptions, especially for a large business that wants to work closely with a small business. You want to help them write their proposal because it's going to be a better proposal if you got your hands in it. You want to provide them some resources to make them more competitive, to allow them to help them do their scope of the work. Maybe you want to move some employees to their payroll. All these sorts of things could be evidence of affiliation. But if you're their mentor and you put it in the mentor-protégé agreement, it's going to be off the table. So it's a great way for a larger business, a large business in particular, or one that's about to be large, to work closely with a small business without taking the risk of certain types of affiliation. In some cases, agencies are providing source selection credit. I've seen this occasionally. A solicitation will provide a source selection credit for those evaluation factor and best value type procurement for mentors and protégés. There is some will say public relations benefit to say, hey, we're putting our money where our mouth is. We support small business. Just look, we've got this protégé or these multiple protégés. Some large businesses take a long view and say, look, today's small business is tomorrow's medium business, is 10 years from now is large business. We're going to help them get there, and we're going to develop some long-standing industry allies this way. And so there are businesses that take kind of long view in that regard. And it's kind of I respect that when people are thinking not just about tomorrow, but of what's 10 years down the road. And then joint venturing, the SBA, again, the 8A program, now the all small program, allows this joint venturing capability between a large business and a small business for set-aside contracts, unique to those programs. All right, so what do you do? How do you get one of these things? Well, no matter which agency you're going with, you have to agree typically on what benefits the protege is going to get in advance. Spell those out in a written mentor-protege agreement, and we'll talk toward the very end of this presentation about where you can find the SBA's all-small mentor-protege template. They do start with a template. I hate the word template because it gives people the impression that it's, it's just a quick fill-in-the-blank sort of thing, and it's more complicated than that. The SBA really, what they provided you is format. They provide you a format for how to put this together, but the meat of it is still up to you. The specific benefits, SBA is now telling you what the mentor needs to provide the protege, nor is any other agency that sponsors these. That's up to you. So you figure that stuff out, but the benefits need to be spelled out in writing. Agencies increasingly, SBA does ask for this. They want milestones, timelines, updates to better ensure that the protege receives the promised benefits. And so, for example, in the SBA's 8A program, the SBA requires as part of the 8A company's annual report that the 8A company show whether they got the benefits the mentor promised them during that year. And SBA will take nasty action against the mentor if it is failing to abide by its promises. All right, affiliation and joint venturing. So, well, again, we've ascertained that a mentor-protege program is an assistance program. It's not in itself a joint venturing or teaming relationship. However, a SBA mentor-protege program, SBA-approved mentor-protege relationship, whether it be in the 8A program or the new all-small program, can allow special joint venturing benefits. Additionally, participants in the SBA's 8A all-small or the DOD's mentor-protege program can have certain affiliation benefits. So I want to talk about what those are in a little more detail. So here's the background on this, and this is why I'm I'm repeating this, and I hate to be repetitive, but this stuff comes up so often and it confuses people that I feel like it's worth mentioning a few times, that not all federal mentor-protege programs provide these benefits. They don't. The programs that provided, again, SBA 8A, SBA all-small and for joint venturing and affiliation benefits, and DOD also has the affiliation benefits but not the joint venturing. Here's why, because I think it's helpful for everyone to understand why that's the case. And the answer is interagency squabbling, turf war, turf war between federal agencies with contractors caught in the middle. And this is why. So SBA used to have a regulation on the books until about 2011 that said participants in federal mentor-protege programs were exempt from affiliation based on the assistance provided by the mentor to the protege. That's what the regulation said. And what's a federal mentor-protege program? Well, let's say that NASA has a mentor-protege program. That's a federal mentor-protege program, isn't it? Let's say State Department has a mentor-protege program. That's a federal program. So aren't all these programs offering an exemption from affiliation? Well, what happened was that a number of agencies started creating their own mentor-protege programs. DOD, that mentor-protege program was created by Congress back in the 80s. SBA had their 8A mentor-protege program. And what a lot of procuring agencies were hearing was, we like SBA 8A mentor-protege program. Large businesses liked it. Small businesses liked it. DOD was getting positive feedback for its program. And so a number of these other agencies, keep in mind, they're under the gun here. SBA is keeping track of their small business goals, the prime contract, subcontract level. They're thinking about ways to promote small business. And one of the things that came to mind naturally was, hey, let's do a State Department mentor-protege program. Let's do a Treasury Department mentor-protege program. And they did, and so you saw that list of mentor-protege programs on the prior slide, about 15 in total. And most of those, other than DOD and 8A, were created by the agencies themselves. The Congress didn't mandate they do it. The agencies used their own regulatory authority to create the programs. And while they were at it, a lot of the agencies said that participants in the agency mentor-protege programs were exempt from affiliation based on the benefits that the mentor provided the protege. In other words, those benefits could not be used to find affiliation. And, of course, the agencies, I think, in doing that were relying on this prior SBA regulation. The SBA itself seems to be saying that that's the case. So we're going to take them at their word and put it in our guidance on the program. And some of these agencies put it in their regulations. VA did, for example, Treasury did. And said, if you sign up for this program, you will not be affiliated with your mentor based on the assistance that the mentor provides you. Here's the problem. SBA was like, oops, we didn't mean that. We didn't mean that. We didn't mean that that any federal agency could just create a mentor-protégé program and exempt companies from affiliation. We're SBA. We get to decide who's affiliated, and we didn't vet any of these programs. We don't know if they're being well run or not. We don't know if they're accepting companies they should accept or not. We don't like it. We don't like the idea that any other agency is stepping on our toes, and despite our own regulation, saying that companies could be exempt for affiliation for participating in a program that we here at SBA have not vetted and have not approved. So in 2011, SBA changed their own regulations, and the regulation, which currently still is in effect, says that SBA will only recognize an exception from affiliation, an affiliation shield for mentor-protégé programs that A, have been authorized directly by Congress, and there's only one of those, DOD, or B, have been specifically sanctioned by the SBA, which at this point in time is just the SBA's own programs, the 8A program and a mentor-protégé program, the all-small mentor-protégé program. So SBA left the door open and said another agency could come to us and get their program vetted and approved by us, but unless they do that, we're not going to, they can say what they want about affiliation, but when someone gets size protested, guess who decides it? Not VA, not Treasury, not state, not DHS, us. And we don't care about your silly mentor-protégé program, other agency, because you haven't run it by us. Agency turf war. And so that's where things stood for several years. So here's a case that came up in 2012, the year after the regulation was passed, that proves the point. This is an SBA size appeal case decided by the SBA Office of Hearings and Appeals called J.R. Conklin Associates. And what happened in that case was, and I won't belabor this point, but there was a size protest of an SDVOSB. The SDVOSB defended the protest, saying I'm not affiliated with that company because they're my mentor under the VA's mentor-protégé program. And the SBA Office of Hearings and Appeals said, we don't care. I mean, we know that the VA's regulations say there's an exception from affiliation for mentors and their protégés, but the SBA disagrees. The SBA says that VA program has not been approved. Participants in the VA mentor-protégé program, despite what VA says, and not just says, but says in its regulations, despite what VA says, sorry, no exception from affiliation. Sorry, J.R. Conklin, you lose your size appeal. You are affiliated with your mentor. So the bottom line is, under the prior law that existed up until the last year or so, only the SBA Mentor-Protégé Program and the DOD Mentor-Protégé Program provided an exception from affiliation. Other programs said they did, but they didn't really, because when the deciders, the SBA, took a look at it, they didn't credit those exceptions from affiliation. And that's true to this day. That if you're a participant today in the VA's Mentor-Protégé Program, you do not have an exception from affiliation. Same with NASA, same with Treasury, state, DHS, et cetera, et cetera. But now there's a new avenue, the new all-small Mentor-Protégé Program, a broad exception from affiliation. Again, SBA says one of two things have to happen. Either Congress had to sanction the program, create it essentially, or SBA had to approve it. Obviously, SBA approved its own program, so the exception from affiliation exists with all small, which we're about to talk about. Under the SBA's 8A program as well, the joint venturing benefit. And here's where the joint venturing benefit kicks in. So we started the presentation talking about how there is a common misconception that mentor-protégé is a form of teaming relationship. It is not. What mentor-protégé is, though, is an exception from affiliation, which can be relevant if you're doing a lot of subcontracting together, to make sure SBA isn't considering that an indicia of affiliation. But more to the point, it's a special way for a large business and small business to joint venture together for set-aside contracts. That's what it is. That's where, when people talk about a mentor-protégé joint venture, the purpose of the mentor-protégé agreement in that joint venture is to take the mentor size off the table. Because when the SBA determines if a joint venture is or is not a small business, the way the SBA does it is by looking to see whether each member of the joint venture qualifies as a small business under the NAICS code and size standard assigned to the solicitation. So if you've got Company A and Company B, and it's a $7 million size standard, Company A is $5 million, Company B is $5 million, then the joint venture qualifies as a small business. You don't need a mentor-protégé agreement to make that happen. And that's another common misconception, that if both parties to the joint venture are small, then there is no need for a mentor-protégé agreement for you to joint venture for that procurement. where mentor-protege gets involved in teaming and in joint venturing specifically is when one of the parties to that would-be joint venture is a large business. And when that is the case, then under the SBA's 8A mentor-protege program and all small mentor-protege program, if you have an approved mentor-protege relationship, the joint venture can qualify as small based only on the protege's size. So long as the protege is small, doesn't matter how big the mentor is. So that's the rule currently. And the SBA has adopted this benefit as long-standing benefit under the 8A Mentor-Protégé Program, but SBA has adopted a similar benefit as part of All Small. All right, let's get into the meat of All Small then. So here we are. That's our background. Mentor-Protégé programs generally, kind of some history about different agencies creating them, SBA, DOD. Now we got All Small. So where does All Small come from? A couple statutes here. Again, I like to understand the history of where this stuff comes from, the policy behind it. I think it's good to know what and why these programs exist. So Congress in 2010, the Small Business Jobs Act, you may have heard of that statute. It's a major piece of legislation dealing with all sorts of different small business issues. But in that act, you know, Congress had heard good things about the 8A Mentor-Protégé program. It heard good things about the DOD Mentor-Protégé program and some others. You know, some folks liked the other agency Mentor-Protégé programs. They hadn't been faced with a size determination or had any issues with it. They just liked the Mentor-Protégé concept, and it was helping promote small business procurement both at the prime and subcontract level, which is an ongoing goal of Congress, is to increase the small business contracting. So what Congress did in 2010 is they said, look, we've heard good things about your 8A Mentor-Protégé program, SBA. We will authorize you to essentially expand this program to SDVUSBs, hub zones, and WSBs. Now, we're not requiring you to create a new Mentor-Protégé program for those three categories, but you're allowed to do it if you want to, SBA. You can. And SBA, to its credit, said, "Yep, okay, we're going to do that. That's a good idea. We're going to go with it and design a Mentor-Protégé program for SDVUSBs, hub zones, and WSBs." And SBA got working on some proposed regulations. Well, SBA was somewhere in the process of that, and I don't know exactly where, when Congress came back in 2013 in the National Defense Authorization Act and said, you know what, SBA, we still like your 8A Mentor-Protégé program. We understand that 3 years ago we authorized you to create Mentor-Protégé programs for SDVUSBs, hub zones, and WSBs, but we here at Congress are hearing from small businesses that don't have any of those socioeconomic classifications, and they're saying, what about us? We'd like mentoring too. You know, why can't every small business have a mentor if it's able to get one? And Congress said, you know what, we agree. We will authorize you, SBA, to create a Mentor-Protégé program for all small businesses if you want to do it. And we here in Congress are not going to, again, demand that you do it, but we're authorizing you to do it if you want. And SBA, again, to its credit, said, you know what, that's a good idea, Congress. We're going to pick up and do that. We're going to go create a Mentor-Protégé program for all small businesses, which is, of course, where we get the name of the program. While I was at it, Congress, you know, and Congress gets a rap for not getting things done, and sometimes that's true, but sometimes they are able to get some stuff done despite the partisan bickering that sometimes is part of our political process. And one of the things that Congress did in the 2013 National Defense Authorization Act was it essentially he served as a judge and jury in this turf war between the SBA and the other agencies. Congress said, look, agencies, we hear that there's a dispute between SBA and other agencies as to whether those programs can offer an exception to affiliation. And we, Congress, have listened to both sides, and we're ruling in the SBA's favor. That's essentially what Congress said. Said other agencies, once SBA releases its proposed rule on this issue, the issue of Mentor-Protégé programs in the government generally, then you, other agencies, will have 1 year to conform your program to SBA's expectations and get SBA to approve it if you want to. And if you don't get SBA's approval within that 1 year period, your program goes away. And, you know, so SBA, you can essentially standardize the other agencies' Mentor-Protégé programs, tell them what they must look like, require them to come to you hat in hand for approval, and if the program meets your needs, SBA, satisfies you, then you, SBA, bless that program, and then at that point the program confers that exception from affiliation and can continue on. But if you don't, if they don't come to you for approval, or you don't like what you see and a year passes, then the program just goes away, although current participants in the programs can play out their program terms. So Congress essentially ruled in SBA's favor on this interagency turf battle that we've been talking about. So SBA published their final rule. This is 2013, so we got 2010, then 2013, now 2016. This last fall, August 24th, SBA finally published their final rule creating this new all-small mentor-protégé program, which at the time they called the universal mentor-protégé. They've now started calling it the all-small, which I think is the name that's going to stick long-term here. But SBA's final rule was we're going to create a single universal mentor-protégé program. We're not going to create separate programs for WSBs and hub zones and so forth. That was one option available to them. They could have created a bunch of different mentor-protégé programs. Instead, they said, nope, we're going to just lump everybody together, one universal program. How do you qualify? Well, you can qualify as a protégé if you're small in your primary NAICS code, and there's a regulatory definition of that, by the way. It's essentially somewhat oversimplified, but the NAICS code in which the company did more business in its prior fiscal year than any other NAICS code. There's some other factors that could be considered if it's a closer case. But if you're small in your primary NAICS code, then you can be a protégé. Or if you're small in a secondary NAICS code that you want to develop business in, then you can qualify as a protégé in that NAICS code too. So you think about how companies grow over time. That second piece, which was subject to some debate, is actually pretty important. Let's say that you're a plumbing company and you're about to hit your size standard, which I think is about 14 million or so in plumbing, and you're just starting to kind of dip your toes into the world of general contracting, general construction, which is a 36.5 million size standard. Well, according to SBA, you can now get a mentor as a general contractor to mentor you, even though that's not your primary NAICS code. There's a lot of room to run in the small business field between 14 million and 36.5. So that's SBA's approach now. Small in your primary NAICS or small in a secondary NAICS in which you intend to develop. But with respect to that second part, the secondary NAICS code, SBA's guidance has been, and this is up on their website now, that to be approved in a secondary NAICS code, you have to have done some business there. You can't just pluck a NAICS code out of thin air in which you've done no business and get mentoring in it. So you have to have done a little bit of business in that NAICS code. I think one of my clients was told something in the nature of 25,000, 30,000 or something like that to be considered in a NAICS code. So secondary NAICS code is possible, but not if you've done no work at all in that NAICS code. Who can be a mentor? Any for-profit business, large or small. So we talked earlier about the misconception that a mentor has to be a large business. That's true for DOD, but not otherwise. SBA all small, same thing. Most of the mentors are probably going to end up being large businesses. That's the way it is in the 8A world, but not all of them. And so if you're a small business, especially on the larger side of small, you're getting toward your size standard and want to keep your toes in that 8A or 8A or small business world, one way to do that is to develop a strong relationship with a protégé. I've also seen companies doing this that are small businesses, but they sell, they're not SDVOSBs. They sell a lot to VA. After the Kingdom Ware decision came up, they said, if we're not an SDVOSB, our VA sales are going to be in trouble. Let's mentor an SDVOSB, start doing some joint ventures with that company under the mentor-protégé agreement. So there are reasons why smaller businesses may want to take advantage of being a mentor as well as being a protégé. Interestingly, the SBA has said you can be a mentor and protégé at the same time. You can be a mentor and protégé at the same time in different NAICS codes. You can't be mentor and protégé in the same NAICS code. But for example, that plumbing company could be a mentor to another small plumbing company because this company knows plumbing. They're about to exceed their size standard. They're perfectly well positioned to mentor a plumbing company, but they're just dipping their toes into general contracting and need a mentor in that NAICS code, and that's just fine. They could be the mentor and protégé at the same time under different NAICS codes. A mentor cannot own more than 40% of the protégé, and that's at any step in the process. So there is a specific piece of the regulation that says a mentor can, in order to capitalize the protégé, purchase up to a 40% interest in the protégé, or could theoretically have, and I haven't seen this looked at yet, up to a 40% interest at the time of application. But the SBA has said that if the mentor owns more than 40% of the protege, that the application will not be approved at the outset. And by the way, I have yet to see how one will be treated going in with the 40%. You know, theoretically that's doable, but it does raise the issue of, are you sort of proposing to mentor yourself? And so we'll see how the SBA actually interprets that when those applications come through. Can you have multiple proteges? You know, prospective mentors are asking this a lot, you know, because they see the advantages of this program. They're like, well, wait a second, you know, we want an 8A protege, we want a woman-owned protege, we want a hub-zone protege, we want one in a different industry, you know, et cetera, et cetera. And, you know, good news for mentors is that you can have up to 3 with the SBA's permission. You know, the SBA says that a mentor will usually have no more than 1 protege, but if we give you permission, you could have up to 3. And, you know, yet to see how this plays out in the all-small program, because this has only been up and running for a few months, but the regulations suggest it's going to be treated much like it is on the 8A side currently, which means that the SBA is really looking for conflict of interest. You know, the SBA is looking to see in the 8A world long-standing, because I have clients who have multiple proteges in the 8A world, and what's the SBA looking for when they approve that 2nd or 3rd protege? They are looking to say, hey, mentor, is mentoring this 2nd company going to create a potential conflict of interest with your obligations to the 1st? Most importantly, are they likely to bid on the same stuff? Is the mentor going to have to choose which protege to joint venture with for a particular procurement? And so historically, the SBA has been looking to see, you know, are the proteges in different industries? Are they in different geographical areas? You know, are they unlikely to be bidding on the same work such that the mentor isn't going to have to make a decision which protege to team with on an upcoming job? Because if that's the case, then the mentor's obligations and its loyalty to its proteges is compromised. It has to pick and choose. So that's what the SBA has looked at in the 8A world. I think that's probably what they're going to be looking at in the all-small world as well. What's interesting, and I have not seen this yet, again, because of the limited time this program has been up and running, is whether diversity of socioeconomic status will be a basis for approving a 2nd protege. In other words, you know, the SBA has looked for different industries because that means the companies are less likely to compete with one another or unlikely to compete with one another. Will they think the same if you approach SBA and say, this is our hub zone protege, they only bid hub zone work, that over there is our SDVUSB protege, they only bid SDVSB work. They're not eligible for each other's contracts. Is that enough? And the answer is, I don't know, but it's an interesting question because that's what a lot of mentors want. They want proteges are in similar industries but with different socioeconomic codes so that they can get pieces of the pie across the spectrum of set-aside work. So we'll see how that plays out. But up to 3 with SBA permission. By the way, this is 3 proteges across the SBA's 2 programs. And so the SBA has, you know, if you have a protege in some other program that the SBA doesn't really consider a real mentor-protege program like the NASA program, the SBA is not going to be too worried about that. But if you already have 3 8A proteges, if you're a large company and you have 3 8A proteges, then you're out. And the SBA aggregates the number between the 8A and all small and says between those 2 programs you can have 3. So in other words, you can't have 6 SBA proteges, 3 8A and 3 all small. It's 3 aggregated between the 2 programs. As far as proteges go, they could have, it will typically have just 1 mentor, and that's true. You know, most proteges do not have 2 mentors. In the world of mentor-protege, it's been this way in the 8A world for some time. The honest truth is the mentors are in more demand than the proteges. The proteges are certainly bringing value to this relationship, and the good proteges in particular, the ones that are going places that people want to do business with. But the fact remains that in the ordinary course, the mentors are in greater demand than the proteges, and so most proteges don't really have the opportunity to get a 2nd mentor. Some do, and the SBA program does allow it, again, looking at conflict of interest. SBA permission, you know, that protege can teach me plumbing, or mentor can teach me plumbing, that one over there can teach me electrical, neither one knows anything about the other's line of work, I need 2 mentors. That is doable. It's probably not likely going to happen a lot, but it is doable under the all-small program. And as I mentioned, a company can serve as both a mentor and protege at the same time in different NAICS codes. All right, so you want to do this. You want to become a mentor and or protege. How do you do it? You have to enter into a written agreement. We talked about how all the mentor-protege programs require a written agreement, and that's true here too. You need a written agreement. One of my final slides here today tells you where you can get the SBA's template, which I prefer to to think of as a starting point or form that you can delve into and use as your starting point for developing this, but you have to have a written mentor-protege agreement. By the way, you also have to have a business plan if you're the protege. You have to have a business plan, and that's made clear by it's not in the regulations, but it's clear from the SBA's website and from their instructions that the SBA's all small mentor-protege form, template, starting point, whatever you want to call it, says the assistance needs to be tailored to your business plan. Well, you got to have a business plan for that, and they got that component of the requirement from the 8A program. You know, that's what the 8A program has long required. But the 8A program, of course, is special because when you're admitted to the 8A program, you work with the SBA to prepare a special 8A business plan on a form that the SBA, if they're doing a good job with you, is kind of working on it with you so that you do have a good, strong business plan as an 8A company. You know, that's the idea anyway. Not all small businesses have a business plan. You know, some do. Most should. Some of them are not very good business plans, or they were developed a long time ago in order to just try and get some financing somewhere, and they're not really set up to be used in this setting. But a business plan is what the SBA is looking for there as well, and that's something to think about when you go in for this application. Business plan, written agreement. Changes have to be approved by the SBA. The agreement has to be approved on the front end by the SBA. Theoretically, the agreement is subject to reauthorization every year, but in reality, it's a 3-year period because what the SBA regulations say is that it's assumed it's reauthorized, it's automatically reauthorized every year until the 3rd year. At that point, the SBA can approve a second 3-year term after the 3rd year expires, but it has to be a formal approval. There's no automatic 4th year. They can approve a second 3-year term. And then SBA says, and that's it. You know, a single mentor-protege relationship cannot last longer than 6 years. We don't want permanent mentor-protege alliances. You know, it's meant to be an assistance program. After 6 years, protege, you better have learned everything you're going to learn from that mentor. Time to move on. Doesn't mean you can't get another mentor. Mentor can't replace them with another protege, but 6 years max. 8A mentor-protege agreements, by the way, can be transferred to the all-small. So, you know, if you've got an existing 8A mentor-protege agreement, but the 8A company is going to graduate, you know, in the past, that agreement just went away because the company's not 8A anymore. But now SBA has said you can just transfer that agreement straight into the Mentor-Protégé Program, the all-small Mentor-Protégé Program, and keep that agreement going. So nice benefit for graduating 8A companies. What are the benefits here? Well, you know, here's just what the SBA 8A program has said all along. The mentor and protege are not deemed affiliated based on assistance provided by the mentor to the protege. So if it's covered by that mentor-protege agreement and approved by SBA, then the SBA can't use it to find you affiliated. They can still find you affiliated for other reasons. That doesn't give you complete discretion to do whatever the heck you want. You know, if I've got a protege and I've got an assistance agreement with them, but then I go buy 100% of the protege company, well, that wasn't covered by the assistance agreement. I just did something that created an affiliation, still going to be found affiliated. Or, you know, I've got a mentor-protege agreement in place. They're an 8A company. I'm not. I get under their contract and I'm doing 100% of the work. Well, I'm still not allowed to do that. There's a limitation on subcontracting that prohibits it. It's an ostensible subcontractor affiliation violation as well. So you still can't break the law. But affiliation, if it's covered by the mentor-protege agreement, is off the table. And, of course, the kicker, you know, why most mentors want to do this, and many proteges too, the mentor and protege may joint venture as a small business for any prime contract or subcontract for which the protege qualifies as small. So that's it. Mentor and protege may joint venture as a small business for any prime contract or subcontract for which a protege qualifies as small. And that means that if you have a solicitation with, let's say it's an architect and engineering, or excuse me, an architecture solicitation, it's got $7 million size standard. The Architectural Services NAICS code has a $7 million size standard. Let's say you're a $5 million architecture firm. And let's say that your mentor is a $500 million architecture firm. You form a joint venture with your mentor. You're operating under an SBA-approved all-small mentor-protege agreement. That joint venture gets protested. Someone says that's not a small business, that because that company over there is $500 million. It's a little bit ahead of the size standard. Well, if you've got an SBA-approved mentor-protege agreement and your joint venture complies with all the regulatory requirements, your joint venture agreement has to comply with a laundry list of requirements. But if those criteria are met, then the joint venture is small. The mentor size is disregarded. And so the SBA says, yep, they're off the table. XX, that $500 million company, not going to look at them. Who's left? The $5 million protege, they're a small business, joint venture qualifies. So it's a very, very significant benefit. You know, you think about the landscape of government contracting here and where this is heading. You know, the mentor can be any size. And so you think, let's say there's a set-aside competition. We'll go back to our example of the architecture firm. There's a $7 million size standard, and there's six offers submitted, and 5 of them are from what we'll call ordinary small businesses that qualify under a $7 million size standard, and the 6th is from somebody who's got a joint venture with this household name $500 million firm, you know. That's a competitive advantage. You know, it doesn't mean they're guaranteed to win, but that is a competitive advantage. It cannot be denied. And the flip side is, you know, see how extensive this program involvement in it gets. Picture the same solicitation. There's 6 bids. 5 of them are joint ventures with large household name mentors backing this thing. The last is you, and you don't have a mentor. You're out there by yourself as an ordinary small business. Will you lose? Not necessarily. Maybe you'll beat all those mentor-protege joint ventures. But is that a competitive disadvantage? I think it is. You know, it's a competitive disadvantage. This is a powerful program, both for those who use it and potentially for those who don't, depending on how this gets used moving forward. We talked about the mandatory provisions of the joint venture agreements to benefit from that exception from affiliation. Very important that the joint venture agreement meet every criteria that the SBA has in its regulations. And so if you're going to do a mentor-protege joint venture agreement, there's going to be a regulation that specifies for each socioeconomic type what that joint venture agreement has to contain. They're almost all the same, but you want to look at the specific regulation. If you're going after an STVOSB set-aside, for example, then the joint venture agreement needs to meet the criteria of 13 C.F.R. 125.18, which is the STVOSB regulation. So if the joint venture agreement doesn't contain the mandatory provisions, omits even one, gets one of them wrong, then the joint venture doesn't qualify. So it's important to get the joint venture agreement exactly right. And look, I'm biased, but I will tell you this. Relying on templates is a very, very bad idea. You know, there are a lot of bad templates floating around out there that people are relying on that don't meet the regulatory criteria. And even the templates that used to meet the regulatory criteria, the SBA changed most of these rules last summer. So unless it's a very new template, even if it was great and actually did the trick and survived a protest a few years ago, it's not good anymore. So be very, very, very wary, because I've seen folks who have spent a lot of money on the back end with lawyers trying to fix a problem, and usually unsuccessfully, that could have been avoided with an hour or two with a lawyer on the front end with a joint venture agreement review. But that's me. I'm biased. The protege has to perform at least 40% of the joint venture's work if you do this. Again, this is, and I'm not going to go too much into the weeds on this. People get very confused about it, and I understand. I've had half-hour or longer conversations about this of this line itself. What is 40% of the joint venture's work? At its most basic, it is the 40% of whatever it is the joint venture does. The joint venture is the prime contractor. If the joint venture has no subcontractors, then 40% of the joint venture's work is the same as 40% of all the contract work. If the joint venture does have subcontractors, then it's 40% of the part that isn't subcontracted. And keeping in mind that the joint venture partners can't double dip. You know, the mentor can't do both 60% of the joint venture's work and then also be a subcontractor. Doesn't work like that. The procuring agency has to. SBA has said, and this is important because people come to me and they say, where in the FAR, or where is the FAR that says that procuring agency must consider the past performance of both joint venture partners? And the answer is there ain't one. There's no FAR that says that. There's no FAR provision, FAR clause that says that. There is Part 15 has a piece that says that the procuring agency should consider the past performance of major subcontractors and teammates, but should isn't the same as must. So I always have to answer that question. It's one of those things people think it's there because it makes sense. They should have to consider the past performance of the JV partners, right? right? And now they do, but it's not in the FAR. It's in the SBA's regulations. The SBA's regulations, which are good law, I mean, no matter what your contracting officer says. But the contracting officers sometimes have the perspective that if it isn't in the FAR, it doesn't count, and that's not true. The SBA's regulations since last summer say that the procuring agency must take into account the past performance of individual joint venture members, which of course makes sense. You know, if you've got an unpopulated, limited-term joint venture, and now the only past performance the SBA will consider is what the JV did itself, well, that kind of misunderstands the entire purpose of the joint venture structure anyway, which is a limited-term arrangement, and it makes it it's a disincentive to form these joint ventures. SBA doesn't want that. So both mentor and protege past performance must be considered, not in the FAR, but it is in the SBA's regulations. If the contracting officer asks, that's where it is. SBA's final rule on all small says that, again, just as Congress directed, agencies other than DOD can't continue their existing Mentor-Protégé programs unless and until approved by SBA. The other agencies will have up to one year from the date of the final rule, which again is August 24th, 2016, to obtain SBA approval of their existing programs if they want to. SBA has sort of questioned whether these other agencies even need Mentor-Protégé programs anymore. SBA's position, I think, is, hey, you know, we now got you covered. We got all small. So, you know, what more can you state or you Treasury bring to the table here? But as Congress directed, SBA has to give the agencies the opportunity to decide for themselves whether they want to continue their own mentor-protege programs or whether they prefer to just kind of let it go and let SBA handle this field. And I think a lot of agencies will take the latter approach. A lot of agencies, I think, did this primarily, create mentor-protege programs primarily because until recently, SBA's was only available to the 8A companies, and that left everybody else in need of a program for themselves. The SBA rule, as I mentioned, was issued in July, took effect in August. SBA began accepting applications on October 1st to the all-small program. Effective November 1st, the application has been through an electronic portal. So SBA has an actual portal that you go to. In October, they were accepting applications, but you had to do some email submissions, and now got this portal up and running that you can go to and submit your application electronically. That's where you go if you want to apply. That's the website to go apply to the all-small program. As I mentioned, you should use the SBA's Mentor-Protégé template as your starting point. It's available for download on that website referenced right there. Do keep in mind that that is your format. That's how SBA wants you to present the information. But for the most part, it's not the substance. You know, SBA has some boilerplate stuff in there, but the meat of it is the actual assistance that the mentor agrees to provide the protege. And SBA provides a handy list of potential categories that we talked about, like financial assistance and marketing and so on, but doesn't tell you what the assistance needs to be, because of course that's going to be an individual determination based on the protege's needs. And that's where the heart of this mentor-protege agreement is. The heart of the negotiation between the mentor and the protege is what specifically does this protege need? How is the mentor going to provide that? When are they going to provide it? The who, what, where, when, and how sort of details about the actual assistance. All right, let's see if we can get the next slide up here. All right, well, I'm having a little issue with the next slide, so let's see. There we go, and that is it. So I'm going to take some questions now. I saw we had several come in during the presentation. I do want to thank you all again for attending. If you don't have time to stick around for questions, I certainly won't take it personally if you decide to head out now, but please do respond to the survey questions if you're able. For more information, again, here's where you can contact me offline. You know, that's my telephone, email address, visit smallgovcon.com to sign up for our free monthly electronic newsletter. We send that out the last day or so of each business day or so of each month. You don't have to be a client to get that, and that highlights some of the stuff that's going on in government contracting. Tons always going on. You know, right now my anticipation is, for example, we're going to be seeing in the near term the new administration repealing some executive orders that have been in place, especially regarding labor and employment and government contracting. So it's always something happening here. As I mentioned, we've been publishing this blog for about 5 years and have already found about almost 1,000 posts about the comings and goings in the government contracting world. As plain English as we can make it. The occasional bad joke, but that's the price of reading. So please go to SmallGovCon. That's the book, Small Business Guide to Government Contracts. It is a guide to some of the most common compliance issues that arise for small businesses and government contracting. So please check that out. That's not free, unlike the blog, but it is relatively inexpensive, about $25 or so on Amazon. So I'm going to go ahead and take a few questions. If you just hold on for a second, I'll start reading these, and we'll take it from there.
Thank you, Steven. If you have any questions that you have thought of since we've concluded the presentation, please feel free to shoot those over. We're going to spend about 15 minutes here to go through a few of these. So again, take a few moments to type those in as well.
Very good. All right, well, let's start at the top here. So first question, I've heard that a joint venture can only win 3 contracts over a 2-year period. Is this true for mentor-protégé joint ventures as well, from Nicole? So very good question. So this is a common theme that comes up in when talking about joint ventures is what's called 3 and 2 rule. And there's a bit of a misconception about what the 3 and 2 rule is. It's commonly viewed as a hard cap on the number of awards that a joint venture can receive, 3 contracts over 2 years. In fact, it's not quite that strict. What it says is it's an SBA affiliation rule that says that if a specific joint venture wins more than 3 contracts over a 2-year period, the SBA may deem the joint venture partners affiliated for all purposes, which of course is a bad thing. So you probably should treat it sort of as a cap on awards. You don't want to be affiliated for all purposes. And there is no exception to that for an all-small mentor-protégé joint venture. The 3 and 2 rule could lead to an affiliation between a mentor and protégé. But there's a very easy workaround. The 3 and 2 rule, as I have said, including in forums in which the SBA has been there to hear me, that it is, in my opinion, one of the silliest rules in government contracting, because at the end of the day, it is little more than a gotcha for people who don't know the 3 and 2 rule. Because the way you get around the 3 and 2 rule is that when you win that 3rd contract, you form a new joint venture. Because the 3 and 2 rule is specific to a joint venture entity, not specific to the joint venture partners. So if Company A and Company B have a joint venture, it wins 3 contracts, they just go ahead and form a new JV, JV2, JV B, whatever you want to call it, and the clock starts at 0. So it's an easy workaround. There's a case that came up a few years ago where a pair of joint venturers, mentor-protégé JV, had won like 9 contracts over a 4-year period, but or I think it's 15 contracts over a 4-year period, something like that, something a lot. But they had done it through multiple JVs. They never violated 3 and 2. They were savvy. They weren't gotten by the gotcha, and SBA said not affiliated. So 3 and 2 I think does apply, or should be assumed to apply, but just, take it for what it is. When you hit that 3rd award, form a new joint venture. Second question, Nicole, as well. If I form a mentor-protégé joint venture to pursue a solicitation, does the SBA need to approve the JV in advance? If you form a joint venture, mentor-protégé joint venture, does the SBA need to approve the joint venture in advance? Very good question, because this comes up, the SBA approval process comes up a lot. The answer is only if you're going after an 8A contract. The SBA pre-approves joint ventures for 8A contracts only. Doesn't mean that the SBA won't review a joint venture agreement for another type of contract, but the review will happen after the fact if there's a protest. And so let's say you use your all-small mentor-protégé joint venture to pursue a small business set-aside contract. That joint venture has to contain certain required provisions, just like an 8A, but the SBA doesn't look at it in advance. But if you win the contract, someone files a protest, the SBA will look at it then. So it's not a mechanism to avoid complying with the regulatory requirements. It's just a question of when the SBA will look at it. And that's both a good and a bad thing. I think a lot of folks enjoy the lack of red tape on the front end when they don't have to worry about SBA pre-approval. But the nice thing about SBA pre-approval is that most of the time in the 8A world, if there's something that's missing or incomplete or wrong with the joint venture agreement, you get another bite at the apple. The SBA calls you up or sends you an email and says, hey, guys, you need to fix this piece of your joint venture agreement, and you do. And so you can still be eligible for the contract. For a non-8A joint venture, because there's no SBA pre-approval, it doesn't get looked at until after award. If there's something wrong with the joint venture agreement, there's no second chance. They just take your contract away. So it's all the more, you want to get it right no matter which program you're going after, but all the more important to get it right if it's not an 8A contract, because the penalty is so much more severe in the typical case. One final caveat there, if you're going after a VA SDVOSB or VOSB contract, then the SBA doesn't need to pre-approve the joint venture, but the VA CVE, Center for Verification and Evaluation, does. And so they need to separately verify that joint venture. They just did that. I just heard from one of my clients today, got their joint venture verified. It only took a couple weeks, so, but they will do that. They have to do that before the joint venture could be awarded a CVE VA set-aside contract. All right, let me move down here. What's the definition of mentor, Beth asked. 13 C.F.R. 125.9b references concerns but doesn't clarify parent versus subsidiary. If a firm has 6 subsidiaries, can each have a mentor-protégé? That's an interesting question, Beth, and I don't know that SBA has ever formally answered that. You're correct that the rule doesn't specify what happens if a large conglomerate has a bunch of different subsidiaries, sister companies, et cetera. Can each of those companies have multiple protégés? In practice, I've seen that. I've seen the SBA allow that, where I have a client in this situation where they are part of a corporate family, and my client that's part of the corporate family has 3 protégés, and other pieces of their corporate family have other protégés. So at least in a couple instances in practice, that seems to be how SBA has done it, but I'm not aware of any rule that specifically says yay or nay on that point. So that, that's just what I've seen anecdotally happen before. And whether there, anytime something is just based on what I've seen versus a regulation or at least a published policy, such as in an SBA standard operating procedure, I'm always a little hesitant in that internal policies can change. It could differ by SBA district. These joint ventures or mentor-protégés are approved nationally, but the joint ventures are approved by district. So it just, who knows? But that's what I've seen. It's a very, very good question, and one I unfortunately don't have a solid answer for. Christopher asked, if you already have a mentor-protégé agreement through the SBA, is there any benefit to pursuing a mentor-protégé agreement with another agency with the same parties? Not unless there's some agency-specific benefit to be gained by that. Because if you have the 8A mentor-protégé agreement in place, then you have government-wide the ability to do the joint venturing without regard to the mentor size, and you have the exception from affiliation. So you have those key benefits. There's not any other contractual benefit that's going to be added by taking the same parties and signing up for State Department or Treasury or something like that. The one caveat I will say is if there's some reason, if the agency in question is saying we're going to give evaluation credit to people who are participating in our program, we're going to look favorably on that, then sure, it's worth considering for that reason if there's an agency-specific or even solicitation-specific reason to do that. But at a macro level, the answer is no, I don't think that there is. Let's see. Cindy, good to see you, Cindy. I hope you're doing well. Cindy asks, can an 8A company out of the development phase be approved for a mentor? Yeah, yes, Cindy, they absolutely can. An 8A company can be approved to be a mentor. In fact, they could be a mentor under all small, for example, and a protégé under 8A. If they're still in the 8A program, it would have to be in different NAICS codes as we discussed, but there's no restriction on an 8A company, especially as you mentioned out of the development phase, which for those who aren't familiar with the 8A program, that's what the SBA calls the first 4 years in the 8A program is the development phase, and the last 5 years, it's a 9-year program term total, the last 5 years known as the transition stage. So yes, an 8A company could be approved as a mentor, and especially if they're out of the development phase, that shows that they're probably in a position where they are more likely to have the capability, resources, et cetera, to do that. Beth asked, regarding the limit of 3 protégés for large business across small business and 8A programs, does that apply only to SBA Mentor-Protégés or across all federal agency-sponsored Mentor-Protégés? The answer to that is, at least the regulatory answer is only SBA programs, so only the SBA 8A and small business Mentor-Protégé programs. So the SBA says you can only have 3 protégés under those programs. They have not, at least under the regulations and the final rule, said that they're going to add in any protégés under other programs. I think because SBA, in some level, doesn't even really view those programs other than DOD as legitimate. You know, they don't carry the benefits of affiliation. SBA hasn't approved them. The SBA does ask, as part of the all small Mentor-Protégé template, to tell them whether you have any other existing Mentor-Protégé relationships. So they are gathering that information, you know, potentially, in fact, to see if there's an existing affiliation between you. If you already have a longstanding DHS Mentor-Protégé, the SBA's position is that anything you're doing there could be grounds for affiliation. But with respect to the 3 protégé limit, that is specific to 8A and all small. I think importantly, since DOD is still continues to be a viable program, you could theoretically have 3 SBA protégés as well as however many DOD is going to let you have under their Mentor-Protégé program. Again, SBA's perspective is kind of reading between the lines of their final rule appears to be that the DOD program really serves a different purpose than the SBA and all small, that those of the SBA's programs are designed first and foremost to assist small businesses in developing as prime contractors, whereas DOD's is intended first and foremost to assist small businesses in developing as subcontractors and large mentors to expand their small business base, their subcontractor base. So SBA doesn't really view the one as overlapping too much on the other between DOD and SBA. Let's see. John asked, does the 3 or 6 year term apply also to an 8A MP? I thought MP would last until the 8A graduates, and you're right, John, it does. So the 3 and 6 year term is unique to the all small program. You know, the 8A program, of course, has been around for many years before the all small program was created, and the 8A program served as the starting point when the SBA was developing its regulations. In fact, many of the all small regulations are essentially cut and paste from the 8A. But one distinction, of course, is in the 8A program, there's a natural cutoff point to how long a mentor-protege relationship can last. The 8A program, as I was just talking about in response to Cindy's question, has a maximum program term of 9 years, and you know, allowing for some ramp-up time to get a mentor-protege approved. You know, 8 years or so is about the maximum that a single mentor-protege relationship can last in the 8A program before the protege just graduates and it's over. When the SBA took that framework and applied it to all small, well, they realized, hey, you know, an 8A company can only be 8A for 9 years, but a small business can be small forever. A hub zone can be hub zone forever. Woman-owned, service-disabled, same thing. And again, they didn't want permanent mentor-protege alliances, so they decided to impose a time period limit of 3 years per term, 6 years total, over on the all-small side. But they have not adopted a similar regulation in 8A. In 8A, the protege's natural 8A term continues to serve as the term limit essentially for a mentor-protege, and they do have to be reauthorized every year, but once the protege graduates, then that's over there, the natural endpoint there. John Michael asked how the revenues from a project flow. Do we have to have the project collecting 51% of the revenues, profits? Good question. So the SBA has been tweaking their regulations on this point recently too, and I can't go into huge depth on this, both because this is a more complicated topic and once we get into the weeds, and because at some point then you got to talk to an accountant, which I have not. But what the regulations now say across the programs, there used to be some differentiation, and the SBA fortunately has cleared this up, is that the profits are split commensurate with work share. So the work share within the joint venture. That within the joint venture, as we talked about, the protege must do 40% of the work, no less. It can do more. Floor 40%. The mentor can do up to 60% of the work. Whatever the ultimate split of work is, that's how profits are supposed to be allocated according to work share, which is different than ownership. A lot of these joint ventures are set up as LLCs, which is usually the advisable way to go, in my opinion. The ownership of the LLC has to be at least 51% of the protege. So unlike most companies here in the 8A and all small joint venture world, and even joint venturing outside of the Mentor-Protégé Program, because these regulations apply when you got two small businesses doing it too, joint venturing that is, then profit split is not commensurate with ownership, which is unusual from a corporate standpoint. Instead, it's divorced from ownership. It's commensurate with work share. So that's it. Let's see. Ben asking, cover the special exemptions to Mentor-Protégé programs as it relates to Indian, Native, Alaska Native, and Native Hawaiian companies. Very briefly, because we are running short on time. I've got eight minutes or so here. There's not really a Mentor-Protégé exemption for those types of companies. We'll call natives, ANCs, and NHOs. What those companies enjoy, among other things, are affiliation benefits. The ordinary affiliation rules have some special exceptions where those companies won't be affiliated with parent or subsidiary or sister companies based on common ownership, common management, and common shared administrative services. So that's where you see the same family, for example, of ANC companies, and they're also allowed to have multiple 8As at the same time in different NAICS codes. So you'll see, hey, this ANC's got 4 8As currently, and each one of them has a mentor, and they can do that so long as each of those companies is small within its own NAICS code, because those companies aren't affiliated with their sister companies and their parent companies because of the special exception from affiliation. So it's really, the special rule there is really not so much a Mentor-Protégé rule as it is an affiliation rule, but what it does from the Mentor-Protégé side is it allows these companies that would otherwise be deemed large and ineligible to be a protege, it allows them to become small and be proteges when they wouldn't otherwise be able to do that. Cindy asks, under the new small business Mentor-Protégé agreement, can a Mentor-Protégé establish a joint venture for other than small, for woman-owned, hub-zone, or SUVSB? Yeah, absolutely. So the new Mentor-Protégé program allows a Mentor-Protégé joint venture to qualify essentially for any contract for which the protege would qualify. So if you've got a protege that's a hub zone, let's say, and the mentor is a large business, obviously non-hub zone, then a properly structured Mentor-Protégé joint venture will qualify as hub zone because it will be small thanks to the Mentor-Protégé agreement. That's one component. And it will qualify as hub zone because the joint venture agreement will meet all the requirements of the hub zone joint venture regulation, which I forget off the top of my head what that is. I think it's 126.616, but don't quote me on that. Anyway, so yes, it can go after other forms of contracts, not just small business. Darren asks, it's my understanding a protege can only have 2 mentors. Is this at any one time or a lifetime cap? That's at one point in time, so that's not a lifetime cap on mentors there. About how long has it been taking? Ben also asked SBA to approve all small Mentor-Protégé applications. Not long, actually, so far. We'll see. You know, I had some clients that submitted theirs in October and were approved by November, of a month or so. I think the time frames have gotten a little longer for holidays coming, and people they're probably getting more applications there, but it's been surprisingly fast so far. So a month, 6 weeks maybe, who knows? I mean, I don't know how long one submitted today would take, but as far as government approval processes go, this one so far has been good. So kudos to this office for doing it. Let's see. Dan asked, I've got about 5 minutes that I'm going to have to run. Can you confirm that the regulation specifically precludes companies being both a mentor and protege under the same NAICS code? Small businesses might want both a mentor to compete for small business work and a protege with another business classification in the same company. I will have to, Dan, go back and check the regulatory language, but the I think the intent is clear that the SBA would find that to be a conflict of interest, and they're basically saying you got to pick and choose. Do you need training in this industry, or are you capable of training someone in this industry? You got to pick one or the other, and whether that's dead set in the regulation or it's just implicit from the way it's structured, I'm not sure. But I think you'd have a tough time convincing the SBA that you both need training and are capable of training somebody in the same industry. John asked, do you use the SBA Mentor-Protégé template for 8A Mentor-Protégés? Well, not the same template. SBA has a separate template for 8A Mentor-Protégé. They look pretty similar, but the SBA 8A1 is different. There's some more details that are required. The formatting is different. So it'll look familiar if you've looked at the all-small template and then pull up the 8A, but do a Google search for that. If you can't find it, reach out to me. I'm happy to help you find that. Rob asks, to prevent a finding of affiliation, it appears to be important to define all assistance or benefit that's being provided by the mentor to the protege within the mentor-protege agreement. Is that correct? Yeah, so that is correct, Rob. So the shield from affiliation is that, and the regulatory language essentially says that the mentor and protege will not be deemed affiliate based on the assistance that's provided to the mentor or to the protege under the mentor-protege agreement. And so that means that if you want a specific element of assistance to be exempt from affiliation, it needs to be included in the mentor-protege agreement. The mentor-protege agreement is not a license to just exclude all relationships that you might have from a finding of affiliation. It is a shield from the items that the SBA essentially has seen, reviewed, and approved. That's what it's for. So if you think that you're going to be doing something, you have to be careful about what you do with it, because you want to make sure that the mentor-protege agreement includes all the relationships that you want to be exempt from affiliation to get that shield. By the same token, you want to be sure that you don't promise things that you're not sure you're going to deliver as the mentor. If you think, well, what we might do, we might award 5 subcontracts to the protege, but we don't know that. We're going to have to find a way to finesse that a little bit, because you don't want to say, we will award them 5 subcontracts, and then a year later, SBA comes back and says, where are the 5 subcontracts? You didn't meet your mentoring obligation. So you got to finesse the language a little bit, or if need be, amend the mentor-protege agreement, because it can be amended with SBA approval. Cindy asked, should a company pursue the 8A Mentor-Protégé program, or should a company just pursue the all-small? Depends where you are in the process. If you're an 8A company, I would still probably go with the 8A Mentor-Protégé, just because you don't have that 3-year cutoff for reapproval and so on. You could work more closely with your 8A office on it, but they both offer the same benefits. So it's one or the other. If you're not 8A, then your choice is limited to all small. If you're the mentor, then the choice should be based on who you want to be your protege. Do you want, if the 8A company is the best choice, then then you can go either way. If your prospective protege isn't 8A, then of course your choice is made for you there. Brandon asking, a regular certified small business qualifies a protege under the all-small mentor-protege program. There's no such thing as a certified small business, but I'm assuming we're talking about a self-certified small business. The answer is yes, you can. So all-small really does mean all-small. You don't have to be 8A, don't have to be woman-owned, don't have to be HUD-zone, don't have to be service-disabled. You can be any of those things, but you don't have to be. You can be a quote-unquote ordinary small business, so long as you're small in your primary NAICS code, or you're small in that secondary NAICS code in which you intend to receive mentoring, and you've done a little bit of business in that code, then you can qualify. Joseph asked how many joint ventures can a mentor-protege joint venture form. We kind of touched on that with 3 and 2, so in the interest of time, we'll move from that. As a joint venture contract specific only for one contract, the answer is sort of yes and no. The joint venture agreement needs to be developed around a certain contract initially. If you pursue a second or third or fourth contract, or however many it is, because 3 awards is the limit, not three offers, then you can use the same joint venture agreement, but you have to do an amendment or addendum to the joint venture agreement to reflect those items, those required provisions in the joint venture agreement that are contract specific. And when you look at the requirements, you'll see what I mean, because some of them are like, identify the project manager. Well, you might be bidding the same PM on 6 jobs, but you probably won't, so you're going to have to amend the joint venture agreement for those items. There's, half a dozen or so that might change, but it saves you some work. You don't have to amend the whole joint venture agreement. I'm going to do one more question here, then unfortunately we're going to have to go, and then, those we didn't get to, please feel free to reach out to me offline, and then we will do that. So let's see. We'll see if I can just scroll down and see what we've got here. Let's see. For some very good questions here. I really appreciate this. Jonathan asked how long the Mentor-Protégé process takes. So this is good. So I think this is a good question because this one comes up a lot. And these are all good questions, by the way. I really appreciate everyone's attention today. I mean, fantastic questions and attention. In fact, if we're an hour and a half in and we got 81 people still on the line, it really says something about you as the audience and your interest in this topic. So thank you for that. So Sean asks, you mentioned that on a JV, the procuring agency must accept the past performance of a mentor. How about in a teaming agreement, prime sub, must procuring agency accept past performance in this situation? And the reason I chose this as the last question is because this one does come up a lot. These are all good questions. This one I hear a lot. So it's the same when I talk about where is the FAR that says this or that. You would think there would be a FAR regulation that says the procuring agency has to consider the past performance of a major subcontractor or a mentor if the mentor is your subcontractor, or you think the SBA would have such a regulation. There isn't one. There isn't one. FAR 15305, if you look at it, if it's an acquisition being conducted under FAR Part 15, which is the negotiated procurements section, FAR 15305 gets the closest to this. It says that the contracting agency should consider the past performance of major subcontractors or subcontractors who play a critical role in the procurement. But the GAO has interpreted that provision over the years and said, well, should is not the same thing as must. The agency should do it, but they didn't. Well, they didn't do what they should do, but they didn't say must. They didn't say shall. And the SBA, although they did create this requirement for contracting officers as part of the joint venture regulations, has yet to do anything similar for prime sub. I think it would be nice if they did. I think that it would be nice if they did, but I think some of the procuring agencies have pushed back a little bit on that and said, no, there may be good reasons sometime where we don't want to consider subcontractor past performance or don't want to consider it equally with the prime because they're not managing the job, things like that. So in the ordinary course, the agency does consider the past performance, whether of a major significant subcontractor, be that a mentor or otherwise. But if it's not clear from the solicitation, then it's a good topic for a Q&A before proposals go in. You don't want to assume that the agency is going to do what it quote-unquote should do. So, well, that needs to wrap us up. I don't want to run over anymore. Again, thank you so much to SAME and the Small Business Council. Those whose questions I wasn't able to get to, I do apologize. Again, so fantastic that we had such great interest in this topic. Do feel free to reach out to me offline, so long as your question isn't, as I said, and most of these don't appear to be, specific legal advice, but just along the educational track here. That I'm happy to answer those by email or any other method that you would prefer to contact me. So please go ahead and do that. Again, thank you very much. I'll turn it back over to Alex to wrap us up. I appreciate everyone's time and attention this afternoon.
Yes, thank you, Steven, for that. We sincerely appreciate it. And just on behalf of SAME and the Small Business Council, we appreciate everyone's participation and do hope that this webinar has been useful. If you have any additional questions, please feel free to reach out to Steven. And then on the SAME side, feel free to reach out to me or Nicole Matthews as well. But at this point, I believe our webinar is concluded, and please feel free to disconnect. And if you would, do complete that survey that will pop up as well. Thank you.